There's a nursing home in Massachusetts right now with 3 empty chairs at the nurses' station that were full a month ago. Not because anyone quit, not because anyone was fired, because 9 people in black robes in Washington, D.C. decided a case that had nothing to do with nursing homes on paper and everything to do with them in practice. And if you have a parent in assisted living, a spouse in home care, or a plan to age in place with help from an aide who comes 3 times a week, what happened this year is already moving toward your front door, whether anyone has told you yet or not. This is not a story about immigration policy. I want to say that clearly before we go any further, because it is easy to hear the words Supreme Court and immigration in the same sentence and assume this does not apply to you. It applies to you if you are over 60. It applies to you if you have a parent over 80. It applies to you if you are one of the 53 million unpaid family caregivers in this country who are already stretched thin and quietly praying the paid help doesn't disappear. Stay with me for the next few minutes, because I'm going to walk you through exactly what the ruling says, exactly who it affects, and exactly what you can do about it starting today. On June 25th of this year, the Supreme Court issued its decision in Mullen v. Doe, a case that had been working its way through the federal courts for months. The vote was 6-3. Justice Alito wrote for the majority. Justices Kagan, Sotomayor, and Jackson dissented. The question in front of the court was narrow on its face. Does the federal government have the authority to end temporary protected status for a group of immigrants without federal courts being able to step in and second-guess that decision? Temporary protected status, or TPS, is a humanitarian designation that lets people from countries facing war, natural disaster, or political collapse live and work legally in the United States for a defined period of time. It is not a green card. It is not citizenship. It is a bridge, and it has existed in some form since the early 1990s. The Supreme Court ruled that federal courts generally cannot review the executive branch's decisions on when that bridge gets taken away. In this specific case, that meant the ruling upheld the termination of TPS protections for approximately 350,000 Haitian nationals and about 6,100 Syrian nationals living in the United States. The court also rejected the argument that the decision to end protections for Haitian nationals specifically was driven by unconstitutional racial motivations. 3 justices disagreed strongly enough to write dissenting opinions. But 6 votes were 6 votes, and the ruling is now the law of the land. The legal reasoning behind the majority opinion is worth understanding, because it tells you how durable this ruling is likely to be. The majority's position rested on the idea that decisions about designating and ending temporary protected status fall squarely within the discretion of the executive branch, and that Congress, when it created the TPS program back in 1990, did not intend for federal judges to second-guess the Department of Homeland Security's judgment calls on a country-by-country basis. In practice, that means challenges arguing that a specific termination decision was arbitrary, poorly reasoned, or procedurally flawed are going to have a much harder time getting a federal court to even hear the argument, let alone rule in their favor. The 3 dissenting justices took the opposite view, arguing that closing the courthouse door entirely removes an important check on executive power, particularly in cases where the underlying claim, like the allegation that a decision was racially motivated, involves a constitutional question that courts have traditionally been willing to examine regardless of the underlying subject matter. That disagreement between the majority and the dissent is not just an academic dispute. It is the exact fault line that will determine what happens next for the TPS holders from Honduras, Nicaragua, Nepal, Somalia, Ethiopia, South Sudan, and Burma, who are currently still protected by separate court orders. Lawyers on both sides of those pending cases are already citing this ruling, and how lower courts interpret it over the coming months will determine whether those remaining protections hold or fall in the same direction. Here is where this stops being an abstract legal story and becomes a story about the person changing your mother's bandages or helping your father out of bed every morning. A significant share of the direct care workforce in the United States, the certified nursing assistants, the home health aides, the people who staff overnight shifts in memory care units, are immigrants. And within that workforce, Haitian immigrants in particular have become deeply concentrated in elder care and long-term care roles over the past several years, especially in states like Massachusetts, Florida, and Ohio. Healthcare has been the fastest growing employment sector in the American economy for years now, and it already runs a vacancy rate far higher than most other industries. That means when a large, specific slice of that workforce becomes ineligible to work almost overnight, there's no deep bench of replacement workers waiting in the wings to step in. Industry leaders did not mince words when the ruling came down. The head of Leading Age, the national association representing nonprofit aging services providers, said staff and caregivers who support older adults every day, legal employees who in some communities make up 8% or more of the entire workforce, could now lose their jobs virtually overnight. Argentum, which represents senior living operators, said the decision carries meaningful implications for both providers and residents. And in Massachusetts alone, roughly 45,000 people hold Haitian TPS protections, with about 1,500 of them working in nursing care facilities in that state by itself. Multiply that pattern across every state with a significant Haitian immigrant population, and you start to see the shape of what providers are actually facing. Let's talk about what that actually looks like inside a facility, because the word workforce disruption doesn't mean much until you translate it into a hallway. One nonprofit senior living organization serving 5,000 older adults through 1,500 employees representing 70 different countries described the moment in almost personal terms. Not anger first, sadness first. Sadness that more older adults who will need support in the coming years may not get that support, or may only be able to get it at a price they cannot afford. And here is the number that should stop you cold if you are thinking about your own future or your parents' future. Nearly 70 million people in the United States are now over the age of 65. Roughly 70% of older adults will need some form of long-term care at some point in their lives. That math was already tight before this ruling. It requires more caregiving hands, not fewer. And this decision just reduced the hands available in specific communities, in specific facilities, starting now. What are providers actually going to do about it? This is not speculation. Industry leaders have already said the choices on the table are limited and none of them are good for families. Facilities may have to limit new admissions, meaning the waiting list for a nursing home bed in your area could get longer, not shorter. Some facilities may have to close entire units, consolidating residents and reducing the total capacity available in a region. Home health and home care agencies, the ones sending an aide to your parents' house 3 mornings a week, may have to turn away new requests for service simply because they do not have enough staff to say yes. If you are currently on a waiting list for in-home care, or you are researching a nursing home for a parent right now, this is directly relevant to your timeline, and it is relevant this year, not 5 years from now. Before we go further, it helps to understand what temporary protected status actually is, because a lot of the confusion around this ruling comes from people assuming TPS is the same thing as a Greens card or a path to citizenship. It is not. TPS was created by Congress in 1990, specifically for situations where sending someone back to their home country would be dangerous because of an ongoing armed conflict, an environmental disaster, or some other extraordinary and temporary condition. It has to be renewed periodically by the Department of Homeland Security. And historically, renewal has been treated as a fairly routine administrative process for countries still experiencing the conditions that triggered the designation in the first place. Haiti's TPS designation, for example, has been tied for years to the country's ongoing political instability, gang violence, and the lingering effects of a series of natural disasters. The people covered by it are not recent arrivals in most cases. Many have lived and worked in the United States for the better part of a decade, built families here, and in the specific case we are discussing today, trained and certified to work in some of the most demanding jobs in the entire healthcare system. That context matters, because it explains why the workforce impact of this ruling is not a minor disruption. It is the sudden removal of experienced, already trained, already certified workers from a system that takes months or years to train replacements for. There's a layer of nuance here that matters, and I want to walk through it honestly, rather than tell you the sky is falling everywhere all at once. This ruling does not mean every TPS holder working in elder care lost their status the moment the decision was announced. The Department of Homeland Security still has to issue implementation guidance covering things like work authorization timelines and document validity windows for the people affected. In the days after the ruling, a temporary expiration date connected to a separate district court order was set for July 1st of this year, though it remains unclear whether that date takes effect automatically or whether the department needs to issue additional guidance first. Employers have been advised not to re-verify or change employment documentation for affected workers until that federal guidance is actually issued. In other words, this is unfolding in real time, and the exact timeline for when specific workers lose eligibility is still being worked out at the federal level even as we speak. It is also worth knowing that this ruling does not touch every TPS designation. Protections for people from countries like El Salvador, which remains active through September of this year, along with Sudan, Ukraine, and Lebanon, are still in place for now. And there are separate court-ordered stays currently protecting TPS holders from countries including Honduras, Nicaragua, Nepal, Somalia, Ethiopia, South Sudan, and Burma. But here's the part that should concern anyone paying close attention. Legal analysts following this closely have pointed out that by ruling TPS termination, decisions are largely beyond the reach of judicial review. The Supreme Court weakened the legal foundation that those other stays were resting on. The primary legal backstop that advocates and providers had been relying on to protect workers from other countries just got significantly thinner. Whether those additional groups face the same outcome is now a live, ongoing legal question, not a settled one, and it is one you should expect to see back in the news in the coming months as related cases work through the lower courts. So what do you actually do with all of this if you are a senior, a family caregiver, or someone planning for a parent's care in the near future? Let's get practical, because information without action is just anxiety with extra steps. First, if you have a parent or spouse currently in a nursing home, assisted living community, or receiving home health care, call the facility or agency directly this week and ask 2 specific questions. Ask whether they anticipate staffing changes as a result of recent federal workforce policy shifts, and ask what their contingency plan is if staffing levels drop, including whether current residents or clients would be prioritized to stay or whether services could be reduced. You are entitled to ask these questions, and a well-run facility should have an answer ready, not a shrug. Second, if you are currently searching for a nursing home placement or home care agency for a parent, start that search earlier than you otherwise would have. If waiting lists are likely to lengthen in your region over the coming months, getting your name on a list now, even before you need placement immediately, could meaningfully shorten your wait when the time comes. You can check current staffing data and inspection histories for specific facilities through the Medicare Nursing Home Compare tool at Medicare.gov, which gives you real numbers rather than a facility's own marketing material. Third, reach out to your local area agency on aging, which you can find through ElderCare, ACL.gov. These agencies track regional capacity issues in real time and can tell you whether providers in your specific area are already reporting the kind of admission limits or service reductions we just discussed. They can also connect you with alternative resources, including community-based care options that may not depend on the same workforce pipeline. Fourth, if you are a family caregiver already providing unpaid care and you are worried about picking up additional hours, if paid help becomes harder to find, look into respite care options now rather than waiting for a crisis. Caregiver burnout is a real and well-documented health risk, and knowing your backup options in advance, even ones you hope not to need, puts you in a fundamentally stronger position than scrambling for them during an emergency. Fifth, and this one matters if you employ a home health aide or caregiver directly and privately rather than through an agency, do not take any action on your own, such as asking to re-verify someone's work documents based on assumptions about this ruling. Federal guidance on implementation timelines has not been fully issued as of this recording. Acting prematurely could create legal complications for both you and the person you employ. Wait for confirmed agency guidance, and if you have specific questions about your situation, a consultation with an immigration attorney or employment law professional is worth the cost of the appointment. Sixth, think about the financial side of this now before a shortage forces your hand. When facilities and agencies lose staff, the basic economics of supply and demand do not disappear just because we are talking about caregiving instead of a retail product. Fewer available workers relative to the number of families who need care tends to push prices upward over time, whether that shows up as a higher hourly rate for a home health aide, a higher monthly fee at an assisted living community, or new waiting list deposit requirements that did not exist before. If you have long-term care insurance, this is a good moment to actually read your policy rather than assume you understand what it covers, because some policies cap the hourly reimbursement rate for home care at a fixed dollar figure that was set years ago and may no longer match what agencies in your area are charging today. If your policy has not been reviewed in the last 2 or 3 years, call your insurer and ask directly whether the reimbursement caps in your policy still align with current market rates for care in your region. It is a 15-minute phone call that could prevent a very unpleasant surprise later. Seventh, if you are the one currently providing unpaid care for a parent or spouse, and you have been leaning on the expectation that paid help would eventually become available to give you a break, revisit that plan now, rather than waiting until you are exhausted and searching for options in a crisis. Ask your area agency on aging specifically about respite care voucher programs, adult day programs, and any community-based volunteer caregiver support networks operating in your county. These programs tend to be less affected by the same workforce pressures hitting licensed nursing and home health staff because they often rely on a different pool of volunteers and part-time community workers rather than certified aides. I want to be honest with you about something else because too many channels covering legal news either oversell the panic or bury the real stakes entirely, and neither one serves you. What is confirmed fact is this: the ruling happened. The vote was 6-3. It directly affects hundreds of thousands of workers, a meaningful share of whom work in caregiving roles that seniors and families depend on every single day. Providers across multiple states have already gone on record describing this as a serious operational threat, not a theoretical one. What remains uncertain is the exact pace at which staffing shortages will translate into longer wait lists or reduced services in your specific zip code, because that depends on regional workforce concentration, how quickly providers can recruit and train replacement staff, and how federal implementation guidance actually rolls out over the coming weeks. Anyone telling you they know exactly how bad this will get in your town by a specific date is guessing. What we do know is the direction of the pressure, and the direction is not favorable for families who need care capacity to expand, not contract. There is also a broader piece of this worth sitting with for a moment. The healthcare and elder care industry has spent years describing a math problem that predates this ruling entirely. Nearly 70 million Americans, over 65. 70% of them expected to need long-term care at some point. A workforce that was already short-staffed before this decision reduced it further in specific communities. This ruling did not create the elder care staffing crisis in America. It intensified a crisis that was already underway, and it did so specifically in the segment of the workforce that fills some of the hardest, most essential, least glamorous jobs in the entire healthcare system, the overnight shifts, the bathing and feeding and lifting that keeps a fragile elderly body safe and dignified day after day. If you take one thing away from everything I have just walked you through, let it be this. Do not wait for a crisis at your parents' facility to start asking questions. Call this week, ask about staffing, ask about contingency plans. Get on waiting lists earlier than you think you need to. Check the real inspection and staffing data through Medicare's own tool rather than trusting a glossy brochure. And keep watching this space because the legal questions around the remaining TPS protections for other countries are still working through the courts right now, and how those cases resolve will determine whether this staffing pressure stays contained or spreads further across the system that your family depends on. If this helped you understand what is actually happening and what you can actually do about it, share it with someone who has a parent in care right now because they need this information today, not after the waiting list is already longer. And subscribe because this story is not finished. The implementation guidance is still coming, the related court cases are still pending, and I will be back the moment there's something new and confirmed to tell you.